Hi guys, welcome to Learn Kenyan Law with Wanjiku, and this is the platform where you get legally informed, especially if you're a Kenyan citizen. And for today, we're talking about ICT and the law, and we're specifically going to be talking about the limitation to the right to privacy. As you remember, we talked about the right to privacy, and we're going to now be asking ourselves, are my rights limited when it comes to the right of privacy? And the answer is yes. Your right to privacy has some limitation. And the reason why you have some limitations is because the Kenyan government has passed some of the legislations that are able to interfere with your right to privacy. So now let's talk about the first kind of legislation, that is the National Intelligence Service Act of 2012. The National Intelligence Service Act allows the NIC to investigate, monitor, or interfere with the communications of people under investigation by the National Intelligence Service. So basically what I mean here is that if you're suspected of committing an offense by the National Intelligence Service, then they have the right to investigate you. They have the right to monitor you, and they even have the right to interfere with your communications. They have the right to know who are you talking to. Where are you going? What are you doing? They have that right if you're suspected of committing an offense. It is also important for us to note that the NIC is subjected by parliamentary oversight, presumably by the Intelligence and Security Committee, although this is not clear based on the wordings of the NIC Act. The next kind of legislation that helps the government to interfere with your right to privacy is the Prevention of Terrorism Act. And this specific act allows the government to limit the right to privacy through surveillance. And by wordings, I am going to read it. The limitation of a fundamental right and freedom shall relate to A, the right to privacy to the extent of allowing the privacy of a person's communication to be investigated, intercepted, or otherwise interfered with. So basically, when we're talking about the Prevention of Terrorism Act, if you're suspected of any terrorism activities, then the government has the right to surveil you. The government has the right to investigate. The government has the right to intercept. Who are you talking to? Intercept all of your communications. So this specific legislation limits your right to privacy. The next kind of legislation that we're going to talk about when it comes to the limitation of the right to privacy here in Kenya is the Security Laws Act 2014. And I'm going to read a small section, and it says, the right to privacy to be limited for the purpose of intercepting communication directly relevant in detecting, deterring, and disrupting terrorism. So this specific act is telling us that the government has the right to intercept communication if they want to detect any terrorism activities, if they need to deter any terrorism activities, and if they need to disrupt any terrorism activity. So if you're suspected of terrorism, then you no longer have your right to privacy, because this legislation enables the governments, they are able to issue regulation, and say, let your communication be intercepted. The next kind of legislation that limits your right to privacy here in Kenya is Kenya Information and Communications Regulations of 2013, which is basically for the registration of subscribers of telecommunication services. It is important for us to note that through this legislation, the telecommunication providers are required to give the Kenya Communications Authority access to their systems, their premises, their facilities, their files, their records, and other data for inspection. So basically, if your telecommunication provider is Safaricom or Airtel, they are required to give the Kenya Communication Authority access to their system, their premises, and their files, records, and any other data for inspection. So if the Kenyan Communication Authority wakes up and they say that they want to go and inspect Airtel, Airtel is supposed to be in a position to give them their files, their records, and of course other data. The next important legislation that limits the right to privacy here in Kenya is Kenya Information and Communication Act 2013. This specific legislation requires the telecommunication providers to register your full name, your identity number, your date of birth, gender, physical and postal address before selling a SIM card to you. That is why mostly when you're going to buy a SIM card, you need to give this information. You need to give your name, you need to give out your identity card number, you need to say when you are born, you need to say your gender, where do you live, and your postal address. And of course, by sharing this information, it helps the government to investigate any criminal offense that can be done through your phone number. So basically, by sharing all this information, you're limited when it comes to your right to privacy. The next kind of legislation that limits your right to privacy here in Kenya is Kenya Information and Communication Regulation of 2015, which is for registration of SIM cards. And this specific legislation requires the telecommunication providers to transmit the SIM card registration information to the Communication Authority. So after you have bought your SIM card and given out all of your information, your name, your ID number, your physical address, your postal address, your date of birth, then your telecommunication provider is required to give that information to the Communication Authority. And from this, of course, you no longer have your right to privacy. However, as I have said earlier, this helps the government in deterring crime. For example, if you commit crime using your phone number, at least they are able to track you down. The next kind of legislation that limits your right to privacy is the Computer Misuse and Cybercrimes Act of 2018. And this specific legislation provides the government the powers to prosecute vaguely formulated and broadly defined crimes relating to computers. And by this, the government is able to search computers, including ordering people to decrypt and encrypt data. So it is important for us to note that if you're suspected of any offense, any computer-related offense, the government has the right to just come search your computers, decrypt and encrypt data from your computers. It is important for us to note that this specific legislation, that is the Computer Misuse and Cybercrimes Act of 2018, it has listed the different kind of offenses when it comes to cybercrimes. I would advise you to probably just take a minute and go through them if you can and if you're interested, just so that you know where do you stand when it comes to the offenses of Computer Misuse and Cybercrimes Act. So another important thing for me to note right now is that some civil society organizations have contested 26 sections of the Computer Misuse and Cybercrimes Act on ground that they are contrary to the right to freedom of expression. And these specific sections were suspended pending to full hearing and determination of the case. So this specific act gives the government powers to just come and search your computers and even encrypt data from your computer, especially if you are accused of an offense or even suspected. Thank you so much, guys, for listening to this end. I'm sure by now you're updated when it comes to the limitation of the right to privacy. You know how is your right to privacy limited. Feel free to subscribe. Feel free to like our Instagram and our Facebook pages, and also feel free to watch our different videos. See you next time. Bye.